Hello, everybody! Excited Utterance here. It's a big day, and I have Seraph. Hello, Seraph. How excited are you for this hearing? Just tell us. Tell us how excited you are for this hearing. I know. Like you even got out of bed for it. You even got out of bed early for it. He actually got out of bed for it. Like, he doesn't get out of bed at all, ever. Like, he gets out of bed to, like, eat a couple of little bickies and, do his business. But apart from that, he doesn't get out of bed. But he's out of bed for this one, early. So, I mean, that's something, hey? Yeah, yeah. I know, right? I'm excited. Hey, everybody, it's hearing day. It's hearing day. Hello. For fuck's sake. Hello, welcome. Hey, Donna Barkley. How's it going? Hello, everyone. Hi, Scott Wade. Hi, chat. Wait, don't start. I need to mix a drink. Oh, hey, wait a minute. Just a sec. I have my emotion in lemonade. You like?
It's something.
It's my motion in lemonade.
It's unique.
And I've got my motion to strike.
Oh, God. Okay, Carrot Top.
It's too early for lemonade right now. But there is an emoji in chat for members. There's a lemonade emoji. And there might be a strike. There might be a motion to strike. I think I made one. Pretty sure I did. I have a motion in ginger ale with lime. Does that count? Yes, that's fine. I had to buy a lemon.
Oh.
Which I'm pleased now. Now my fridge smells like lemon.
There you go.
Motion in lemonade. I bought the Surge White Claws to slow down my alcoholism. Cool. See, this is what we're here for, Donna Barkley. All the other chats, most of them, 99% of them, are so like, oh, she's disgusting. She is horrible, disgusting murderer, and this is so appalling and outrageous. How dare you have any fun with this? Come on, lighten the fuck up.
Yeah.
Lighten the fuck up, people. Let's have fun. Why do you think I was an Aussie last time I was on here? Just, for fuck's sake. Probably not just for fuck's sake. Because we've got a fairly good sense of humour over here. We're pretty laid back. Also, justice for Tupac. Like my Tupac shirt.
Yes, you're very
Justice for Tupac. See?
nice.
Yeah, cool. Hey, Roddy. How's it going? Present for roll call. Yes, Melissa's here. Hey. Oh, Melissa made the coolest poster. By the way, I have to show everybody on the Discord. All right, and Mavka's here. All right, let's get going. It's a 2-hour or so hearing. We'll run it on like quicker speed than that. If you've seen it, cool. I'm sure Beautiful Waterfall's seen it. Pretty sure Scott Wade's seen it. If you haven't, minimum spoilers from people who've seen it. But, if there's something cool, I'm not going to get mad at you for giving us a little bit of spoilers away. We don't get mad at anyone here. Because, we're chill as around here, aren't we? Aren't we? Yeah, look how chill. How chill can we possibly be? Right? More chill than Seraph. Then there's something wrong with you. All right, let's go. So, it's a big day for Sarah. It's a big day for Sarah. It's a big old day for Sarah. Let's just move forward. Great Seal, the state of Florida.
The audio sucks.
The audio sucks? Okay.
At times.
Okay, that's fine. We have the controlling audio that we can change.
Yeah,
We can change.
well, but I don't know.
No, we'll see. We will
Yeah, watch out for the volume at the start.
watch out for the volume at the start. All right.
But yeah, Sarah's got a team with her though. Our girl's risen up in the
Oh,
world.
that's fun. That's fun. Oh, is she smiley?
Probably in the beginning.
Oh, okay.
Stevie Wonder filming.
Stevie Wonder.
Either that or the camera guy's drunk.
What is going on?
Aw,
Aww.
there's our girl.
Oh, she's sitting with her back to
Ooh.
us. We don't get to see her.
Who's that cutie with her?
Who's that cutie? Yeah, what's with the blondie? Is she like a paralegal or something?
Probably. Like his
Aw.
whole office.
Oh, look
Owens.
at this. Check her out. She's just like surrounded.
She's got a
Check-
team.
She does have a team.
Like Owen's whole office is working on this. Like he's basically shut down his practice to take this on.
Look at her. Look at him like serving her. Oh, she's like Queen Bee, isn't she?
I feel bad for Owens. I mean, he's ineffective at this point. I mean, it's better than her representing herself, but there's no way.
Oh, you don't know that. Like, he could have other things going on.
You mean other clients?
Yeah.
No, he said he's basically shut down his office.
Ah, okay. Well, it's only for a month.
Yeah, but I mean, that's a lot of money he's missing out on.
You never know.
And-
We don't know. Like, he could have a lot of money. He could have done very well for himself in his career.
He could, but that's
Hey.
still, he's missing out on.
That's true. Oh, hello.
Is there a cat right?
Abundance and Clarity. Hello, Abundance and Clarity. Please like the video. Yes, thank you. Oh, wow, isn't
Cat
that
rated
nice of
us.
you?
Thank you so
Thank
much,
you, Kat. Thank you, Kat. That's really, really nice of you. Hello.
Hey,
Hi. Hey, Kat, would you like to join us? You're welcome to join us if you're interested, but I know you've had a big day of streaming.
yeah.
But if you're interested in the Sarah Boone hearing, which happened today, only a few hours ago, which we're running, and there's going to be trivia, guys. If you stick around to the end, we're going to be doing a court trivia. I'm retired for the night. So happy to lurk. Thank you so much for the invite. Always, whenever you like. Welcome, everybody. Okay, now, why are we... Oh, thank you for gifting 10 memberships as
Aw.
well.
You're so sweet.
Would you like to read those out, please,
Yes.
Darlie?
Factual lie. FFS. Here comes drama. Beautiful waterfall. Angie Leah. Speculatarity incarnated. Mini duck. Mom to boys knit. Curry. Mac and Mr. Bubbles.
Lovely. Hey, FFS, formerly known as For Fuck's Sake, you got one. Cool. Nice to have
you so
nice to have you all here. And Sniffles is here. Good to see you, Sniffles. Alrighty. Thank you, Kat. Much appreciated.
Yes.
Welcome, everyone.
You're
All right,
so
let's hurry up and move this thing along, people. What's going on?
Quiet for a little while.
Chitty chats. Look at her being a rock star with all of her lawyers.
I know. And now she's been, representing herself, so she knows what it's like. So
Because like she can like talk legal notes with them
yeah, exactly.
because she's a lawyer now.
Yes, basically.
Okay, if they went offline for a little bit, law and crime.
Of course.
Oh my god!
Told you.
For making
Sorry,
your
guys.
ears bleed.
Sorry, guys. Ugh.
Okay, I'm gonna turn that down. Are you actually serious?
It gets better.
What is happening?
I muted it on the stream while it gets fixed.
Thank you so much.
Yeah. So yeah, this hearing today is just covers some outstanding motions She just got an attorney about about 3 weeks ago. So he's scrambling to build a defense for her.
Yes, and the trial is on October 7th.
Yes.
So, yes. And she is going with the battered spouse defense, which is very controversial for Sarah Boone. If you're not aware already, if you have been following this case, you will know that she put her boyfriend into a suitcase and just fell asleep.
As one does.
Yes, and then told the police, well, it was not intentional that he died, or that I was not responsible for him dying, therefore, i.e. murder, because it was not intentional. In fact, I'll show you exactly what she said.
Not intentional.
Yes, she said it was not intentional.
Not
many times. However, if the battered spouse defense is going to hold up, then she may have to go back on that one, because if over the years she was made to be in fear of her life, perhaps it was intentional for her to put him in the suitcase and allow him to lose his life in that situation. Because if she was in fear of her life, that makes sense. That's a self-defense situation. Now, the state's going to try and say that today they're going to try and strike. They're going to try and strike the battered spouse defense today. And the thing about that is, it's only a few weeks out from trial. Good luck to Sarah Boone if she is not able to use that defense. Hope they've got a backup plan, guys, if that doesn't work out. All right, let's keep going.
Why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we
How's
begin this
sound?
afternoon? Any housekeeping matters from your side of the ledger, Mr. Owens?
How's sound in chat,
Good,
guys?
I appreciate being here, and I just wanted to introduce my two assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all.
Oh, thank you, Peter.
Anything else, sir?
Hi, welcome.
To the extent we may be hearing from Ms. Boone, ma'am, if you could,
Thank you
please
for
raise your right
joining.
hand. Madam Clerk's going to go ahead and swear you in.
Sounds good? Oh, sweet. I'll put some captions up if I can.
I believe that the first thing that was filed in this case,
Now
just
it's
as a matter of
slow.
No, it's
time,
okay.
was the state's motion the defendant's motion for statement of particulars that was filed on September 2. I've reviewed that. Mr. Owens, you may proceed,
Hey,
sir.
Colleen.
Do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
The video's kind of choppy.
Judge, as you know,
Okay, you can take it.
I filed on behalf of Sarah Boone this motion for
No
statement of
idea why.
particulars,
That's weird.
and in my motion,
I'll pull it
I
up.
quoted the language and the information
If anyone's
she
seeing
was charged with,
choppy video
and the
from your
court
end or
charges
not?
Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another.
You are?
or
Okay.
evincing a
Oh, he's gonna
depraved
stream
mind
it
regardless of
into
human
our,
life did kill George Torres.
Well, he's going to share
Judge,
his
that's
screen
about as
instead
bare
of mine.
bones of an information as you can file in a
Yes?
case.
Okay.
You know, any
Okay, 14:30.
Yes. 14:30, great.
Yep. 2
Get to
seconds,
the
guys.
chopper.
Slight technical glitch, and we fix that up. See, this is why we're co-hosts.
Yes, it helps to have two people when problems arise.
Yeah. Helps to have two people around when little technical glitches arise. So we'll just fix that up.
shot with a
14:30.
firearm that was used, that type of language.
How's it sound?
That is as bare bones. It doesn't
Low?
even spell
It's a little
out
low?
all the essential language of the
It's a
jury
little low, so if you just
instruction,
want to
which
bring it up a
is
little.
Yeah.
crime of second-degree murder, the state
better.
must prove
Thank
the
you.
following three elements beyond a reasonable doubt.
Sorry about that, guys. But thank
One,
you,
the
Dolly, for
victim is
fixing that.
dead. Two, the death was caused by the criminal act of the defendant. Now, there is no
we have captions
language
back?
in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim.
Okay, let me explain that for anyone who's new here. So, justice for Sarah Boone is it's an interesting thing, and I get a lot of anger and things from people, and I don't mean to cause any anger whatsoever. It all started when she was made to go pro se, and she was left all on her own. She didn't want to be pro se, and that bothered me. The legal arguments around that bothered me, but more so, I often do this. I say justice for the defendant. I'm very much defense biased. Now, justice for the defendant actually means the same thing as justice for the victim. And this is where people get a bit confused, right? So if we don't have a fair trial for the defendant, we don't have justice. We just don't. And that's not justice. That means no justice for the victim. That means no justice for anyone involved. Because you know what's going to happen in the end? There'll be an appeal and the whole thing will have to happen again. So everybody deserves justice. Justice isn't just for one person. It's not just for George Therese. Sarah deserves justice as well. Everybody deserves justice. So people kind of get me wrong when I say justice for Sarah Boone. They think I'm some sort of fan of hers or something. I'm absolutely not. I'm a fan of the justice system and of her getting a fair trial. Because especially when she was made to go pro se and she only had like a month, 6 weeks to prepare, I was absolutely 100% sure she was not going to get a fair trial at that point in time.
Yeah.
So that's where that comes from. Yeah. Yeah, usually when you see that, it's for a victim.
This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards
think of one
Mr. Torres?
thing that they're
And
going
3,
to present
is of such a nature that the act
that.
itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein,
Oh,
the state
we have
would
the
also
motion to
cite
strike.
State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979.
We're going to show you in a sec,
And
Denise.
Sutherland
Yeah.
versus State, 305.
I'll show you the
Southern
video.
3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendants in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was
since
in the
we're talking
suitcase
about that.
begging to be left out.
Let's pull it up.
Oh, you've got it?
Yep.
Sweet. I was just going to, yep, sweet. Okay, and but before we start, trigger warning.
Yes.
All right. Before we do this is a little bit disturbing for some, right? So I first saw this, years ago. And I know, like most of us in here, we watch trials all the time and we see nasty exhibits and things. This is a little bit haunting, especially if you're someone who is claustrophobic.
Yeah.
All right. So just be aware you're about to watch somebody like losing their life, kind of.
Although
this
it
is
is
the last moments of his life.
It is a decent sized suitcase, though.
It is a big suitcase, but he is a grown man.
Oh.
But he also was like 5 foot nothing.
Yeah.
And quite skinny. So is the sound fine? We need to hear it. Yeah.
Sarah.
For everything you've done to me. For everything you've done to me.
I don't know. I could be mistaken, but it sounds like she's perhaps a tad intoxicated.
Just a little bit. She might have had one too many lemonades.
Yeah. Or a
Too
couple
many
white
emotions
claws.
in lemonade.
Fuck you.
Sarah.
Fuck you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah.
She says choke.
Choke me, yeah.
Sarah. Sarah. Sarah, I can't breathe, babe.
I
That's
can't
on
breathe,
you.
babe. That's
Sarah,
on
I can't
you.
breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah.
Fuck you.
Fucking breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Shh.
No, FFS. She did say it was hide and seek, that they were
Yeah.
playing hide and seek. But it's not. It can't really be hide and seek. And there's been a couple of stories. There's been a story of her. At one point, she said that he got in there. At another point, she said that she put him in there. But I think it was a bit blurry, like, because obviously she was off her face, drunk, like so drunk that it would have been. I don't know if she would even remember what actually happened.
Well, she
I
did
don't
remember
know.
the video.
She didn't even remember the video existed.
Yeah, the next
She didn't
day.
remember the video existed, and she certainly was like,
Surprise.
I don't know how good of an actor she is, but in the morning, the body cam shows that she was like, "Oh my god, I fell asleep," like that. So I fell asleep like that. So I don't know how good of a liar she is, or an actor more. I don't know how good of an actor she is, and I think she truly did just pass the hell out. So
Yeah.
I
I
think it's not as cut and dry as it looks. Like it looks to me like she's like there in that 2-minute video. It looks like she's just depraved mind and I mean to kill you. However, there is an argument that perhaps she didn't know he was going to die in
And she was
that
just being really
fabric
cruel.
thing. Yeah, and then she actually just passed out, and she would have let him out, but she actually just passed out. But that's not what the state's going to contend. So we'll see. All right, let's keep going.
And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced. And they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day. There are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case.
Also, guys, sorry to keep pausing. It's not related, or it's not really a matter for this trial, but Jorge, the person who died, his brother is currently in jail. Back, I believe, in May. He unalived his, I believe, wife.
A girlfriend.
Or girlfriend.
Stabbed.
Yeah. So
Yeah.
the brother, Jorge, they both were kind of abusive. It's just
Kinda.
kind of, an interesting thing.
Date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did.
Damn good point, Ronnie.
That constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Oh, gee, fancy that. Imagine. Shock.
Moving now to...
Shock.
Give me a moment. and I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's
this one's
second
gonna be
motion
good.
for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions.
Can we pause
Mr.
for a
Owens, you
second,
may
Ellie?
proceed, sir.
No.
I guarantee, and I have not watched this, but the judge is going to overrule every single motion from the defense.
We will
And
see.
no one tell me any spoilers. But he's going to overrule everything. or put off his decision till later.
Yeah.
But he will overrule everything.
Or maybe-
Especially, absolutely, the stuff for additional discovery. Absolutely.
Or maybe grant
No
a very
question.
small thing.
Maybe like a token thing.
Yeah.
Token thing. But absolutely, the additional discovery stuff, no way is he giving any latitude on that. And the defense even threatened a Brady violation. And still, there'll be nothing. He won't move. He will not move. But it will protect you for the purposes of PO, just like any other defendant. PO.
Post office?
What?
No.
What
I
are you
don't
talking
know
about, David? Do you want to come on? David, you're welcome
Yeah.
to.
I can send you a link.
No, he's got
Well,
admin privilege. He can come in.
I'm sure he does. But
You know how to get in by the back door. You can come in if you want. Welcome to. Oh, appeal. Yeah. It'll still protect you for the purposes of the appeal. Yeah, of course. Hey, Badger Witness, how are you?
it's not my software, David.
It's not David. It's not his stupid software. It's just StreamYard.
Not
You can come in if you want.
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation. Now, the argument by the state is well taken.
Oh, it's well taken,
The
eh?
defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before the interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after
Oh, I
this
bet he
event,
has.
No.
So have 12 million
she was
other
asked
people.
to come down to the Orange County
surprised
Sheriff's
the other.
Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced. whether or not Miranda rights were
Yeah.
fully read. I do not believe they were. I believe some of the
Oh.
statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with two homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th.
Wait, could you press pause, please?
I
for a
wanted to
second?
wait to get those policies.
I suppose.
Okay, this is really interesting. So we need to go back and have a look at the interrogation and look at the part where she gets read her Miranda rights, because everybody on YouTube is making fun of this whole give me the Miranda rights thing, this motion
Yeah.
for additional discovery. Everyone's making fun of this, and the state's making fun of it too. They've responded to this request for discovery and gone, well, if the defendant would just use due diligence, she could find it herself. But he's saying that in the interrogation, they didn't read it properly to her. So they didn't actually read it to her in full or read it to her properly.
Yeah.
So if that's the case, that's really interesting that he could get the whole interrogation struck.
I mean, that's what he's trying. I
know that's what he's trying to do, but if it's
Hey.
correct, like if they didn't read her Miranda rights,
Yeah.
this is great on his behalf. If he's found that, this is why people say he's a really good lawyer. Like if he's found something
Yeah.
incorrect in the way they've read those Miranda rights to her, he's right to request it.
Yeah.
We need to go back and have a look at it. Ooh, yeah.
I wanted to wait to get
I'm writing
the
that down.
Miranda rights form. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information
you
and make sure
understand
it's
is the
verified
question
before
at the
you
end.
file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, what was it, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two detectives, the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
It's not a lot to ask for.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding
but
standardized
who was going to file a
Miranda
motion to
cards or
suppress?
policies of law enforcement
She's
agencies.
had no bloody
And I don't believe
competent
that's
lawyers the
admissible at
entire
trial
time.
either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are.
I just had to say one thing.
Sarah Boone needed a lawyer.
Once more, hang on.
Sarah Boone needed a lawyer.
Hey, I love him. He's great.
Yeah, he is. He's good.
Some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client.
Is he talking about
Chelsea? That goes into evidence for the jury to decide whether or not to consider the statement at all.
Oh, maybe.
Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video.
What?
I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements.
He hasn't watched the video.
Because I have, unfortunately, no frame of reference.
But she says number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone?
Wow. So she's the whole, I'm pregnant. Can you just come here to me?
Hang on.
And then
Is this Chelsea? Chelsea was pregnant.
I think so. I think that's what he's saying.
Okay, because she so had COVID. Right?
Yeah.
Like, you remember how she was coughing her head off? And it was February 2020? No question she had COVID, hey?
And didn't,
Like-
that's when I got it. And
Yeah.
I didn't know it was COVID, but
I'm pretty sure she had COVID. I mean, like,
Yeah.
I'm no doctor.
it was
but
going around.
It looked pretty sick. Hey, Steve! The judge does not review evidence before trial or unless it is in motion. Oh, is that why? Okay. So, because I thought evidence does come forth before the judge prior to trial.
Oh, so the judges remain ignorant of all the evidence until it is brought to their attention by the attorneys.
Okay, so unless it is actually put forth to the judge.
Interesting.
So you're saying that that video hasn't been put forth to the judge, so therefore the judge hasn't reviewed it. Okay, that makes sense. And there has been a change of judge as well. Yeah. 2 changes of judge, did you say?
No, 2 judges.
Yeah. Okay. Yeah, there's been 2 judges. Yeah. Thank you for being here, Steve. Also, I can't wait for you to be able to join us sometime. Hint, hint, nudge, nudge, whatever, whenever you can, if you ever can. And I know you're really busy and enjoying your new job. Congratulations. Love having you in chat too, by the way. Steve is a Florida attorney, defense attorney for a really long time. Knows a lot about this stuff. Absolute genius. So thank you so much for being in chat. Let's keep going.
Sarah Boone got there and saw that there was a desk or a place there to retrieve the items. And she saw the male detective and said, is this where I go to get the phone? He said, no. We got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, or I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true.
What?
Fortunately, we have it on audio. Fortunately, we have it on video. there is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they.
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling.
That's in the probable cause statement.
Okay, that it was read verbatim. Okay, excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay?
Okay.
So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every
What's the
deputy
last question
or
then?
homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
does the fact that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so. Along
doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper. That they're used to coerce somebody to talk, and I understand the detective.
But cops do that all the time.
They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay.
Hey,
Mr.
welcome.
J, anything else, sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence
Right,
in the
Scott?
court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief, or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policies, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. in reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is. I think State versus Wright is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Hey! Who would have guessed?
Moving now to
I think that deserves a motion in
The-
lemonade.
defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that
How you doing,
my
Gary?
judicial assistant confirmed that they are not asking to participate in this hearing. And we did confirm that earlier this week. Similar to the other motions that we've heard today.
Owens is
I
doing
have
great.
reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due
He is
process
doing his
costs.
job.
I did see that, sir.
And then there are three motions.
What's
I don't
in
know
my
if you got the
lemonade?
third one.
A motion. There's a motion in the lemonade. That's it.
Are you referring to the motion to return property?
No, relating to cost. Relating to
Don't
cost.
know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a
Tears.
second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Damn it, Margaret.
But I filed a second amended notice of hearing. Can I
Please.
see my copy?
And Mr. J, have you seen that, sir?
State doesn't have a dog in the fight with the expert.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
Keep up the energy, Owens. You can do it.
Okay.
this morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, I believe August the 30th.
That's correct.
You're going to dick not to
I
give you more
asked
time.
Dr. Harper to go down and see Sarah Boone. She lives,
Correct.
Dr. Harper lives in Okaloosa County. And she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to
Not
file
sour.
the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning,
like that.
Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for
Prematurely?
those costs for her to do
me too,
the
buddy.
earlier
That's not always a
work,
good
that
idea.
be considered.
Yeah, me too.
As well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for
Awkward.
the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper. Again, to be retroactively to the time I asked him to be in work on the case. And then the last,
When was that? You're asking nunc-pro-tunc to win on that, also to the August 30th date of your
Yes.
appearance?
if possible, yes.
Hello, babu.
That's when I officially got on the case.
Okay.
Premature
Now,
litigation.
as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I push?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we
Michael
had
Brannon.
on September the 3rd. He's a clinical psychologist. If you'll recall,
He wasn't going to do it.
I'd mentioned him. He had served as an expert in the Marcia Thompson Palm Beach County case.
I recall.
He said he wasn't going
And
to be
so,
part of it, and now
as
he
you
is.
know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist?
David, you're just leaving because you're scared of the
email that
trivia. You know you're going to
attach
lose.
As Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkeland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion, under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on.
Okay, the state is acting
I
like
don't know if
this
I'm going to have an
is some
objection to
big
a written
drama.
report or not. I may, but I'd like to see what the motion said
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard
This is
Time.
completely normal
Is that in person or
to
is that
have
virtual?
two more experts. It's annoying to them because it's happening
Is that
so
in person or
late
is
in
that
the
virtual?
process.
Well, I
But
believe
Okay.
the state's flying in, and I'm going to be there, Judge. That's
They-
the county
the
over
state
from
just
me,
weren't
Santa
expecting
Rosa
this.
County. So
No,
to happen,
about an
No,
hour
they're
drive from
pissed.
me. So I'll be there in person.
they're pissed
We're
that
gonna
a lawyer's
have
come in who can actually do his
Probably
job.
Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed
Yeah,
because that was
prosecutor is
prior
statutory.
to the amended motion seeking indigence costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence
Cheers.
from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to
That'd be
grant
for
your
Sarah.
motion to appoint a forensic psychologist dated September 2, 2024.
Oh my gosh, she got one.
Non-protunct those costs to August 30,
Seriously?
2024. And with regard to the other motion,
yeah, it is cacciatore.
the motion
Yeah,
to
it's
appoint
statutory,
crime
yeah.
scene reconstructionist and death
Yeah, he
investigator.
said that last time we knew
I
his
will
death.
also grant
Oh, wow.
that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly,
Can you tell
the
us anything
certificate of
bad about
service
him?
does not reflect a date.
Just kidding.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good.
Do you know the cute blonde next to Sarah?
Excuse me.
Yeah, that's what I was asking.
No, Dr. Michael Brandt. It had to be filed.
Yeah, he has to. Okay, Steve, do you mind pausing for a second?
Michael
All
Brandt.
right, so I'll ask Steve in chat, but how can the court possibly not give her at least her experts, especially if it's within the JAC budget, right? So Owens is not silly. He's not put forth any experts that are not within budget and can't come forth in time for the trial date. So he is saying, please, can you allow enough time for the depositions to happen? Can there be enough time for these people to actually do their work? But he's not trying to move the trial date or anything like that. He'd love that, but he's not actually pushing any further for there to be a continuance. But he is saying, okay, I have another psychologist and I have a crime scene reconstructionist that I want to put on as an expert, and the state's all like, I don't know who these people are, la, 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 la. Well, judge can't really say that she can't have them, right? Well, I mean, he can, but that would be very dickish of him to do that, right? That would be super duper dickish for him to overrule their motion to bring in these experts.
Yeah.
I mean, she has a right to put forth the defense, and even in this teensy-weensy little time frame that they've got, yeah. I mean, come on. Judge is thinking, how do I protect a future trial from appellate error? Absolutely, and that's what they do, right? Defense attorney is framing it out well, so judge is protecting a verdict. Yeah, 100%. Okay, let's keep going.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones. It had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Birkeland, an amended motion regarding Dr. Harper were filed yesterday.
Love you, Steve.
As was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Birkeland and Dr. Harper are also granted, non pro tunc to August 30. With regard to the motion to appoint clinical psychologists, filed 9/18. I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon. And maybe we'll be able to address that in maybe a similar vein as to the prior response that JICS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department
that guy
and extract
added to chat.
the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any.
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go to work with the law enforcement team and get another imaging if they are not satisfied with the imaging that's provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back.
A Johnson Wiki?
That's an odd name.
Not appointed, authorized back in 2020. as to electronic evidence. So I'm going to deny the motion for return of property.
This guy's kerning really bugs me in his name. He really needs to kern his name better. I'm just saying.
He's
Based
not
on
the
the
one who did the
citations
kerning.
contained in the state's
still.
response.
It's
And
hard when
I'll
you've
leave
got
it up to
an
you,
A and a
Mr.
Y
Owens, to
next
do
to
what you
each
need to do
other.
in order to have that.
And
review.
an N.
All right, I'm gonna do my best. We got about 18 days.
I'll do my best since you were kind of a dick and didn't, lengthen the trial days.
Cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki is a forensic
City
specialist.
girl knows what's
I have no
going
idea if that
on.
order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
But motion to strike.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir. Okay, thank you.
Pause.
Thereafter, on
Pause.
the 15th,
Pause.
an amended notice of intent.
Did you see that?
Enlargement of time.
An enlargement of time. Is Steve or David still in chat at all? Guys, I've never heard of this enlargement of time before. What is this? There's a motion for enlargement of time.
Well,
Getting around.
when you think
Enlargement.
about the significance of the passage of time, it's really significant about the passage of time. You don't know what I'm saying.
So
do you?
you want to? No. But
Okay, never mind.
What are you talking about?
Nothing.
I'm just saying, why are we enlarging time rather than it's not the same as asking for a continuance, right? It's just enlarging time. Enlarging it. Or embiggening it, maybe? But what's with this enlarging thing? I've never heard this wording in court or in a court document before. Someone help. Bring back the lawyers in chat. Is Old Line Red here?
To rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
It's a dirty legal term for an
I
extension.
wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as
I'll
you know,
allow it.
I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand that, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that.
Are we still talking about the phone?
On Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome.
No, we're not.
We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent,
we're back to
alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Kraynick, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially
that's fair enough,
neighbors,
Cat Madison.
court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but to, they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office.
Black is 1999.
And spoke with the secretary and explained to her that here's my CD. I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it.
Prosecutor or the DA's office just not themselves.
She would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it,
text me, baby.
I wanted it as soon as possible.
On
A
the
short time
telephone.
later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But it's just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time.
Yesterday?
I knew this had to be
What happened
filed.
yesterday?
I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone. But battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Ooh.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the video. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice. that this was a potential issue. And the reason being is all the lawyers have been through this, have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered women syndrome within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres.
Oh, this doesn't sound good.
I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone. And the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
That was pretty full on.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to.
I bet you're not surprised. You've seen it all.
But suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him.
Owens is very good. I really wish that there had been more time for him to prepare, because if he did have time to prepare properly, I would love to see what the full argument that he would have put forth would have been, because it's true. What the state's saying is true, that the first argument that he put forth for battered spouse syndrome was incomplete. Mm-hmm. He put forth a bare bones argument just to get it in on time. Yeah. And Owens admitted that, right? And then he's gone and put forth a second amended one because the state called him out on it, which was still pretty bare bones. And Owens even said in that document that his investigation is ongoing. It has to be, because he doesn't have access to everything. He hasn't been through everything. How could he? He's only been on the case for a couple of weeks. It's a bit of a shame, because I think that if this lawyer and his team actually had more time to investigate this properly, there would be a really interesting argument that they could put forth. I'm still keen to hear what they're going to do with as little time as they have, but it's a shame, I think, that they haven't been given the proper amount of time that they would generally have by the court to actually defend her correctly. Yeah, it's interesting, because what he just said, what Owens just said, is that there were 3 times that George was prosecuted for battery, and that Sarah said many times to the prosecutors or to the detectives, look through my phone and see that I was scared of him, he was coming after me, What if that's all true? What if actually this whole narrative that people are talking about her being the primary aggressor, and people are saying that, not just that it was even-handed, that she was the primary aggressor. What if that's not true? What if it's the opposite is true, and she really was scared for her life all those years and was more fighting back? What if that's actually the case? And we're all wrong about this. We don't know. We weren't living in a house. We weren't. So it's just a shame to me that now she's finally got someone really competent and like a team behind her, and they can't do their job properly. Anyway, do you want to keep going?
Yeah. I guess Carol wasn't here for our explanation of what justice is.
Who's Carol?
She just came in.
Okay,
but she said this is stupid and left.
I'll see ya.
Toodles.
Him, punch him, in that she was a habitual alcoholic, and he would have to lay hands on her to restrain her.
Carol.
So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence, and the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome.
I might need some lemonade.
Moreover, it doesn't set forth
to cure my sadness
claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000 I forget which year, 19 case
I love you, city
allows the
girl.
state to point out the things that are promised in the defendant's opening
awesome.
statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth? There's a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
100%
Judge,
John Gary.
They're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But
no.
Judge,
'Cause I agree. There's two different issues here. The first issue is the sufficiency of the notice and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
that's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments. And the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways.
No,
It can't be an
happens to me all the
accident.
time.
And at the same time, be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
It's premature for them to be arguing the question of intent.
but that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located.
I can fix her. What's going on?
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
Too much striking going on.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all
Where's
pertain
Bronca?
to some act
I know.
by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that
That's why
she
we asked
did.
for that.
What overt act or what omission.
Uh-huh.
The overt act, was it zipping him into the suitcase?
But
Was that the overt act
all of
that caused the
but
death?
all of the battered spouse syndrome cases talk about a defensive issue, not meaning defense your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim. or
Calm
by
down, Judge.
in those cases. And battered spouse was used as an explanation for why it is that they did.
Come on, the judge
How
needs
is
to
that
go to
Some
applicable?
lemonade.
judge
to the
needs
case
to
of
go to
I assume they're going to
Cancun.
say she
There's about to
overtly
be a
zipped him up in
snowstorm.
the suitcase. I assume they're going to say he was
Ted Cruz
asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Ooh, this is getting spicy. Judge is shitty.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only
Suitcase.
ones that can answer that, Judge. That's why we asked for the
I
statement.
don't
Suitcase,
understand that
yes.
circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a
She
firearm.
she discharged a firearm.
Remember Dr. Brandon said on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
Ha.
That's for her to testify to.
Florida,
If she
the
wants.
appellate has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
No, he said that like 2 minutes ago.
Yeah, and actually, battered spouse syndrome is a self-defense argument.
Yeah.
So it's not news, Judge. This is not news. So, and also, did you say, Judge, that you haven't seen any of the interrogations or any of the exhibits?
Yeah.
Because that sounds like someone who's seen it. For you to be acting all surprised about this being a self-defense claim, that sounds like someone who's seen her say, ooh.
Not intentional.
Right?
Yeah, because he said self-defense like 2 minutes ago.
Yeah.
I heard that.
Do you think he thinks that she's going to say
Not intentional.
right?
Yeah.
Right? Now that does not sound like a judge who has not seen that.
No.
No, I think he was fibbing. I think he was fibbing. And
Yeah.
I don't think it's a big deal for her to go back on the not intentional thing. Right? Because it was not intentional for him to die. Right?
Maybe she wanted him to sober up and then he wouldn't be so angry when he comes out.
Yeah, I think it was intentional for her to contain him for a bit,
Yeah.
right? But I don't think it was intentional for him to die in that suitcase. And she fell asleep. I think
Yeah.
that's the argument. That's the argument the defense is probably trying to make.
Okay.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
Words that you believe
That's
that
a
the
good
state's
question,
position
Marsha.
is, what you believe that they're going to try to establish, that we don't know what happened before and
She was
after that
drunk.
video. The word self-defense has never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay.
It is a pretzel, old line.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
I caught that just in time, almost just in time. It could have been a lot worse,
Okay.
though.
Now, I am told that this whole section is a big cluster F.
I am, but it's my that we're hearing back again through your microphone.
Sir, you can go to the dollar store and get a pair of headphones with a speaker in them for $2.
Yeah. Now, this dude apparently has tried 250 jury trials. He's been defense attorney for 250 jury trials. Clearly not on Zoom. Yeah.
Yeah. Certainly no trials involving technology.
No, he's a bit of a boomer.
Yeah.
This one. So, do we just fast forward through this? Does anything actually happen?
All right.
Scott in chat, can you tell us?
We can make fun of him a little bit.
Being a boomer? Or does anything actually happen?
Mr. Henderson, we'll give
Yes,
this a
skip
shot,
over
sir.
this.
You can go ahead.
Best skip this part. You can't understand anything he says. Yeah, okay, let's do
That's
it.
what I thought.
And
like, okay. Who the hell is he talking to here?
He's just like walking around talking too. He's like,
A defendant doesn't have to come in before trial and say
Push
that
fast
I am
forward,
relying on
please.
self-defense. Say,
Yeah, he's just like,
he just makes the argument that they don't have to claim battered wife syndrome until the end of trial. Really?
that's
Really?
I think so.
I know that would be raised, not what
the evidence is within it. And that's all I have, Judge. Thanks.
Okay, bye. Bye.
Good Lord. Like he's talking like in 90 degrees angles.
Yeah, he's talking like
largely on the same
right away
page.
from the microphone, which of course is going to cause a lot of noise.
He's like talking in every spot of the room where the microphone can't hear him.
Yeah.
The job is to speak into the microphone, not away from it, sir.
It's like there's a party occurring as well. Wow.
The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what that evidence is used for.
Thank
It's
God
used
that's
to
over.
help a jury understand what an objectively reasonable person would do in those circumstances. And
Poor
there's
guy.
more cases that I've not cited because I didn't know that would
He's
be
going a
raised
little bald.
today, but they kicked out PTSD testimony just last year.
I wonder if he's Jewish. He could use like the little
because it was going
yarmulke
to
and cover that
the
bald spot up.
subjective beliefs of the defendant rather than
should
helping
convert.
the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the
Is that
state's
laid?
position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then like everybody else, we were playing hide and seek.
Dancing with the
Dancing with the
dog.
He got into the suitcase and I
Really?
accidentally went to sleep.
I missed that bit. Does anyone remember that from the interrogation, that they were dancing with the dog?
What the hell does she do with her free time?
Like, that sounds like a really fun household if it weren't for the asphyxiation and all that kind of stuff. Like,
Well-
apart from that, like, and the fact that she had a kid that had to, like, suffer from all that. They do puzzles, they play hide and seek, they get really drunk, they dance with the dog. I didn't even know they had a dog. They had a dog? This is news?
And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence
really,
that day
Masha?
between the two of them. So that's where in the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
Oh no. Dolly,
Mr. Henderson, you're still
help.
muted, sir.
What? Oh,
He's about to talk. No.
sir,
Oh,
hit
God.
the M key. Come on, you can do it.
Sir,
I'm sorry.
Sir.
Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
loud but not clear.
The state
Oh, that's okay. Good job.
That's working now. Kind of.
Experts know about these things and who have the knowledge who can tie these things together and tell why. You can do this.
She's of the opinion that she was suffering from an aged spouse at the time. The notice is simply to require to let them know that we're seeking this avenue. And here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as M. Owens has told you, this is an ongoing process. And we'll probably be adding more, but that's all I have. Thank you all. Right. Thank you very much. The court is going to take the issue under advisement. That's the judge.
Last is the defendant's motion for enlargement of time filed September 17th. Mr. J, have you the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
And I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with a clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo in paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir.
He's very
Paragraph 3 says
good.
Dr. Julie Harper met with defendant
That's
Sarah Boone
why
on
he's
Thursday,
our
September
resident
5,
reader.
2024. Am I looking at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper
Right there.
formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down
But that would be so sad.
the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know
Well,
that
good
the state had
luck.
extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically this rule 3.050 that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly, the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020.
Knock.
She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative, given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Oh,
Any other
come
final
on.
arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
That was just snarky. She has not been in control of her defense all that time at all. She's had a bunch of crap lawyers. To say that they were countless, yeah, people can't count them properly because 4 of them goddamn conflicted out. Well, 3 of them did.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case.
4 is
the court's
countless
prior
now?
findings,
Yeah, right,
numerous
Max.
experts that had been retained throughout this case. And I understand the position that you find yourselves in. But at the same token,
Yeah, she's
based
been
on
in
the same
jail that
analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th.
From his perspective,
So,
I see that,
I believe
yeah.
that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional
fair.
experts or any witnesses at that point in time.
You're talking about jeopardy when the jury's sworn
Correct.
on that Monday, October 7th?
If we're lucky enough to get one on Monday.
So
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting you know,
people know a
full
lot.
disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over when I'm done
Does
with
he sound a
my
bit grumpy?
colloquy. My voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services. That I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30.
100%.
And that will continue
that's a
throughout
lot.
the week. It's easier for me to say, we don't need you. Go home. You don't need to show up for jury service than it is, I need bodies and we don't have them.
Hey,
Now, if we're able to get a jury in one day, fabulous.
Fabulous.
But if we can't, I have that backup.
I believe if we pick the jury in one day, we
Contraction
can try
of
the case in 2
time.
weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court if possible to set 3 weeks. I don't think it's going to take 3
100%,
weeks, but
Denise.
I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay. All right. I'll see what I can do there and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses. It's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge,
Please.
you'll set a deadline that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that
You're a
Mr. Lake
dick.
has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Come on now. That's... The judge pisses me off.
All right, thank you, sir. Earlier today, before your
they
participation,
got
The
I know
least the
that
judge
Mr.
could do...
Owens
Sorry,
had
could you
provided-
pause it for a sec? The least the judge could do is give the defense the maximum amount of time possible before jury selection, before the trial, to get their witnesses in order. Like the maximum space of time. So that's the embiggening,
Yeah.
right? So considering the fact that they are working their asses off, they've come in at the 11th hour and saved this shit so that this trial can run in some semblance of order. Because imagine how shit it would have been if she was going pro se. It would have been an absolute mess, right? So they've come in and they're working really hard to try and make this a fair trial, and also that saves his ass too. That saves Judge Kraynick's ass, because it absolutely was an appellate issue. The fact that she was pro se and unable to prepare effectively for trial. Not so much the fact that he did the 16-page order, which he was so proud of, and waived her right to a public defender. He probably would have got away with that. But more so, the position she was left in with not enough time to prepare, not enough adequate resources to prepare, that, I believe, would have been a big appellate issue. So these people have come in and he's asking for just enough time to get his witnesses in order. And judge is like, no, too bad. So sad. September 26th is 1 week before trial. That is the max amount of time. Yeah, look, I get it. I understand where the state's coming from. I do. But I just feel like if there's anything the judge can do, I feel like he should be bending over backwards for this.
Yeah.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you.
I know. I'm not forgetting
regarding
about the
forensic
state.
psychologist,
I
Dr.
get where they're
Harper,
coming
and
from.
the crime scene investigator, Dr. Birkland. You had advised as the JACS
Hi, Nancelot.
positions on those
Great having you
motions.
here.
Your email has been
It is,
filed.
yeah.
Filed. Subsequent to that, a motion
Thank
to appoint
you.
clinical
Yeah,
psychologist.
really enjoyed having you in chat.
Michael
Good
Brannon
evening.
was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not.
You know what? I don't know whether it's these guys being boomers or not, or whether it's the actual court audio that's really shit.
It would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Abu is not
Not
happy.
a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court
Oh
some
yeah,
background.
he is not happy.
I went back and looked through our files. So far, the defense has incurred, this is prior to the
Gonna pay
Owens
for that.
involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being not this expert, but
Yeah.
was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was let me just get the right name. I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the Battered Spouse Syndrome. And now the defense is requesting a third mental health expert, also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
What are the motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, in excess of the rates for the circuit, those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website and
From 2007?
Because for the Ninth Circuit,
His rates are from 2007 is when they were last changed.
Wow, he's kind, isn't he?
Yeah.
Wow, that's nice of him.
Maybe we should update it after 2020. Just saying.
Maybe.
There
By
was
the way, also, what's going on with his eyebrows?
looks like he has 2 albino carpet beetles on there.
Oh.
Ah.
the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
It's a little inflation
The
between
court is
friends.
going to grant the motion to appoint Dr. Brannon. I know that the state advised that
Fair.
this is not going to be non-proton because I've received nothing from you, Mr. Owens.
What,
that he's
Newt
done any work
Gingrich?
yet. Correct. Okay, so this will be effective as of today, the 17th of February.
September?
Yeah, is that not what I just said? I'm
All
sorry.
experts are a scam.
Experts
I
are
will
usually
take
dicks.
it under advisement, the
Usually
issues
dicks.
pertaining to the battered spouse syndrome and provide a written order.
What, does he have
You
lice?
would advise there were some other issues that you wanted to bring up, sir.
Okay, did you turn the sound down?
No. Oh, yeah, I did.
Oh, they did.
No, I did. Because the
This relates to
Zoom.
the investigator,
Yeah,
Billy
yeah.
Lane, who's working with the defense.
Billy
and his
Lane.
potential costs up to the trial.
Billy! He is the unsung hero of this whole matter.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Barrios
so
as
that,
well.
I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge,
Sarah's
the
good.
other
Yeah.
thing was,
The judge is
of
hard.
course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that
Oh
we can
my
walk
God.
to some degree?
Oh my God, this lawyer is amazing. He wants a
He's-
lapel mic.
He's talking about mics. He cares about audio. Is he the best thing ever?
Well, then again, he just heard his co-counsel doing Zoom, so he's probably sensitive.
yeah,
to it.
there is that. But, I mean,
Sarah Boone needed a lawyer.
love him. Can we start a James Owens fan club?
Yes.
I mean, what a dude. What a dude.
I
And
will have
yet,
to check with
he does.
court admin.
He doesn't care about the
And then the
money.
other
He
thing
is
is-
ethical. I think he really does.
Yeah.
I really do. Really do. Oh, what a man.
Is, we would like Sarah to wear street clothes. So do I need
So,
to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided
Click,
the
he's kind of a dick.
total amount of clothing that they had that would fit Ms. Boone, including shirts, pants, slacks, skirts. And that was the time where she
Underwear.
would be allowed free reign and was going to have the shock device on her lower leg. I
this
would
is gonna
ask that you
cause
can,
so
you
much
can email Ms.
stir.
Click. You can find her information on the Florida Bar webpage and ask her if the public defender would assist you in providing clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you can get it to her. So that's something you have to work with
he said
corrections.
yes.
I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to
Wants
the
to
jury
get her
that she
hair
would like
done.
to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
I believe that's all I have, Judge.
Okay, all right.
Tube
Anything else
top.
that we need to address? All right, anything else, Mr. Owens or
No.
from legal counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock.
I
in the morning.
object
will
to the
endeavor to get
tube
you a
top.
ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you,
All right, thank you all very much. We're off the record.
Oh my God.
Oh, I think Sarah's smiling a little bit.
Is she?
No. Well, I think so.
No.
Ooh, that is a hottie biscotti right there next to her.
Wow. Okay. All right, guys.
Bye. Aw.
Stay with me because.
Really? Did you just grab her chains, woman? What do you think? Sarah Boone's a freaking flight risk?
What?
No, she grabbed her chains to like lead her.
Oh.
Look at that.
Did she?
Yeah. Look. Watch. She's holding onto the back of her.
Look, she's very dangerous. She could grab a piece of luggage at any point in time. You just never know. Alrighty. Okay. I think it might be time. To.
Oh man.
In a minute. Alrighty. Oh, let's go. Oh, I need to make you. I need to embiggen you. It's hearing day trivia time, guys.
Can you
It's
make
hearing
me,
day trivia
can you
time.
make me big?
I'll try.
I'm kind of flaccid right now.
You are a little, aren't you?
Yeah.
Hang on. Let's see. I'll try and make you the same size as me.
Yeah.
Actually, I think, have I got the wrong thingy-me-bob on? Let's see. All right, you need to be in chat, guys. No, not this. Don't move it around. Hella get grumpy if you start moving things around. Alrighty. Yay! Time for motion in lemonade before we start. Alright, panic is setting in. It's a hearing day, Boone and swoon. Mavka's getting ready. Okay, you gotta be in chat to play. You have to be in chat to play. Were you paying attention?
Just type in the number.
Ugh, my lemonade's gone a bit gross. Yes. It's the not intentional hearing day. Maybe it's intentional. Who knows? So the way it works, guys, is it's multiple choice. So you get 4 choices and you press 1, 2, 3, or 4 in chat, and it matters how quickly you put it in. It matters how quickly. That sounded really dirty. Sorry about that. It matters. Okay, how many motions did the defense file for additional discovery? 1, 2, 22, 3, 6, 4, 8. Put your numbers in chat. How many motions did the defense file for additional discovery? 1, 2, 22, 3, 6, or 4, 8. Yes, they filed some motions for additional discovery, guys. Put your answers in chat, everybody. 37. Oh, dear. Yes. So even if you got it right, but lots of other people got it right before you, then you will fall down the leaderboard or maybe not even make it onto the leaderboard at all. And at the end of this, I put it on my community tab and on the Discord. To be on the Discord, you need to be a member because it's a member perk for both myself and Dali. So you can either be a member of my channel or Dali's channel, and then you get to join our fun Discord and get also the notifications. That are
also
much
make
better.
sure you guys are live too. Not back a few seconds.
2. Who have we got? G and
discuss
Oh,
beautiful,
Beautiful waterfall. All right. James Owens said the officers missed what when reading Sarah's Miranda rights? 1. The right to remain silent. 2. The question at the end. 3. Her name. Or 4. An offer of a drink. Put your answers in chat, everybody. James Owens said the officers missed what when reading Sarah's Miranda rights? 1. The right to remain silent. 2. The question at the end. 3. Her name. Or 4. An offer of a drink. Put your answers in chat. Here's an offer of a drink. Yeah. Lovely. Yes. I think we all know. I like the lemonade, so I eat the yellow snow. What are you talking about? Yeah. Oh, that's gross.
She doesn't have snow.
No. Hey, RX girl, good to see you. You hit the wrong number. Oh, no. Oh, no. Oh, no. Oh, no. Oh, no. Next question in 27 seconds. 26, 25, 24, 23. Hurry up, computer. Compute. Just dice. Oh, okay. There we go. We have winners. And people who got it wrong was Bob and someone else. Owens said the state prosecuted George for what? 3 times. 1, stealing luggage. 2, poor dog dancing. 3, catfishing. Or 4, battery of Sarah. Owens said the state prosecuted George for what? 3 times. 1, stealing luggage. 2, poor dog dancing. 3, catfishing. Or 4, battery of Sarah. Everyone's going to get this right.
Or 5, salt and
Oh my
pepper. Is that your lemonade?
I don't know what it was, but it was definitely the cat that did it. Oh dear. I thought the dog dancing was lovely, Marsha. Yeah, I know. Oh, Marsha, you won the last one. Marsha, you won the last one. It was her lemonade. No, it wasn't. No, hopefully it wasn't a lemonade. No, it wasn't. It was nothing nasty. But violating the rules of hide and seek. Yeah, something like that. Da 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 bing. Brr. Oh! Bob got it first, then Dali, then Marsha. Marsha, you're doing really well. Oh, Scott. The state opposed a what of time? 1, enlargement. 2, why is enlargement there twice? 3, engorgement. 4, embiggenment. Oh, I must have made a big mistake and a boo-boo. The state opposed a what of time? 1, enlargement. 2, also enlargement. 3, engorgement. 4, embiggenment. Oh, hell is stuffed up.
I guess everyone who gets 1 and 2 is right.
I guess they must.
You got a 50% chance of getting it right.
You gotta check. Oh, maybe I messed up. I'm sorry. Even Helen messes up. You've got a 50% chance of getting it right if you went 1 or 2. But maybe it's really 3 or 4. Maybe it's really 3 or 4. Maybe. It's rigged.
It's rigged. It's a rigged game.
It's like the election.
Yes. Hella wants you to mail in your votes.
Oh, how did I do that? How did I get that wrong? I had 4 different ones. No.
We're going to find a bunch of new votes the next day.
I hate it when I mess up.
Tell me about it.
I wonder where the dogs are now. Okay, so sorry you guys who went for number 2. We had a 50% chance of getting it right. The woman seated to Sarah's right. Oh, I like this one. Right, was wearing what colored suit? 1, polka dots. 2, tan. 3, grey. Or 4, black. So where Sarah was sitting, think about that. The woman sitting to her right was wearing what?
I just
color
remember the hot
suit?
blonde.
1, polka dots. 2, tan. 3 grey, 4 black. Think about it. Think about it. I'm Sarah. To my right, what colour suit was she wearing? Marsha's doing very well. Marsha's doing very well. Okay. No, Scott. No, Scott. You've been doing pretty badly the whole time, Scott. And Dali, yes, you're only looking at the blonde.
Yeah.
Right? So it wasn't the blonde. It wasn't the blonde. Old Line's doing well too. It was grey. Yes,
Oh.
Old Line, Marsha, and Ghost.
Well, you cheated.
Yes, it was grey. No, you're actually paying attention. Right? Yes. Old Line Red wins again. And Gus Felix and Casper. And then we had Beautiful Waterfall, Marsha, Dali Talk, Yamaha Biker, I'm Bronze Aussie, Mavka, Nick Dev, Bob Masavo, Denise D, Jim Cox, and RX Girl. Yeah! And it's time for what? It's time now for...
I just got a feeling.
Yeah!
Not intentional.
Sarah Boone needed a lawyer.
Reach around.
That was amazing. Reach around. Yay! Congratulations, everybody. Okay, that's enough. Okay.
I am Chris
Boobs,
Hansen
I
with
saw no
Dateline
colour.
NBC, and we're doing a story on computer
Why
predator.
what's going on? Stop it. He should not have access to the soundboard.
I shouldn't.
But I saw no color. I'm not resimistic, whatever. Anyway, that was super fun, and thank you to all the new people who are here today. Yeah, Marsha, you did really well, and Beautiful Waterfall as well. Guys, it was so much fun having you, and what I'm going to do is I'm going to put this leaderboard up on my community tab. I'm going to tweet it, and I'm also going to put it into the Discord. If you guys are not members, consider becoming a member, and you can then access our Discord. So that's for both Dali's channel and my channel. You may already be a member of Dali's channel, in which case you can already be on our Discord. You just need to go over to his membership tab and go to the perks section. Now, something also for you to consider is that, hang on just a minute, we'll keep that up and we'll go this way. Something also for you to consider is the trial is in just a couple of weeks. So it starts on the 7th of October, and we're going to be running it every night from 6 p.m. Eastern onwards. So we're going to be running it in fast mode each night. So I know if you're busy watching something else throughout the day, or you're working or something, it can be really hard to watch a trial. Yeah. So that being the case,
people here are watching the Young Thug trial during the day,
or if you're watching a Young Thug trial, really great way to stay on top of this one as well is come over and we will be running it on fast mode, no lunch breaks, nothing like that. Plus, we are going in with an open mind. So we just like justice, we like watching trials, and we are interested in the arguments from both sides. So a lot of other people that are watching this trial are just all like, we hate Sarah, we just want Sarah to go away for life, la 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 la. We don't really care. We're just really interested in watching an interesting trial.
And it being a fair trial.
And it being a fair trial. And playing games and stuff like this. Yeah. So, this will be a fun place to watch it. And not have to go through the breaks. So, from 6 p.m. Eastern every night of the trial starting October 7, and we'll be doing all the hearings and things here as well. So press the subscribe button and make sure you've got the solid notification button on as well. That way you'll see every time that we go live on this. Thank you so much, everybody. My mind is made up already. Yes, Iman, your mind is made up already. I can't believe it's really happening after all this time. Yeah, I know. Thank you for having me. It's so lovely having you here, Denise. So cool. Congrats, and always remember, even Helen Keller got it right. Okay, sure. Righto. You like the bottom. That was shocking. I got one wrong and I was like, oh, like, you are starting to give Half Irish a run for her money. Half Irish is our 6-time champion. I think you've got about 4 now behind you. You might even have 5. Yeah. All right, that's it. Let me see. Actually, let me just check something out for a minute.
I don't think either of us are streaming tomorrow.
Yes.
I may do Wade Wilson at 5 p.m. Eastern, but just a quick stream. But I'll be back on Saturday, probably 5 p.m. Eastern, to do some more Wade Wilson.
Oh, yes. Okay. So,
Yeah.
So you're not streaming tomorrow, you said?
No, I may tomorrow. I don't know yet.
Okay.
If I do, it'll be a short stream. But there's a lot of new Wade Wilson content that's come out today.
Is there?
Yeah.
Interesting.
Oh,
okay.
yeah.
Fantastic. Alrighty. Well, definitely we'll see you there for that. Thank you, everybody. I will say goodnight now to you guys. And it is my Friday, 10:27 a.m. And it's time now for the song.
Yes.
It is time for the song. It's time for the song. Ready, ready, ready. The song, the song.
Her name was Ella. She was an Aussie. She was a dead lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803. Julia Simpson, excited utterance. Her cat